All right. It is 9 o'clock and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over this case this morning at 9 o'clock. I have joining me on our panel from Orange County, Judge Meredith Sasso, and also from Orange County, Judge Carrie Ann Wozniak. We have one case on the docket at 9 o'clock. It's Schaefer versus State. I am going to assume that the appellant, Mr. Candela, that you would like 5 minutes of rebuttal. Please tell me if I'm incorrect in that assumption. And otherwise, I would just ask everyone, if you're not speaking, please keep your microphone on mute. Also, if there's anything in the background that may cause noise and disrupt the presentation of either attorney, please, for your part, please put your device on mute. I've checked mine as well. And other than that, Mr. Candela, you have the floor.
Thank you, Your Honor. May it please the court. Again, my name is Anthony Candela and I represent Jillian Schaefer. She's the appellant before this court. I do want to reserve 5 minutes, Your Honor. So thank you.
And Mr. Candela, I believe on my screen, you have frozen, your video was frozen. So let's see if he comes back here.
Appealing that motion so that these issues are properly preserved before this court.
Mr. Candela, let me just interrupt you there. You froze briefly, probably for about, I don't know, 15 seconds. So can you please start back from the beginning? Your video froze.
Yes, Your Honor. I apologize. I typically have a very good connection. Start from may it please the court or start from where I beginning my argument?
May it please the court. I won't.
May it please the court, Your Honor. Anthony Candela. I represent Jillian Schaefer. She's the appellant before this court. I would like to reserve 5 minutes of rebuttal time.
You got it.
This case comes before this court on appeal regarding an open plea at the trial level. After the open plea, the appellant moved to withdraw that plea for various grounds, and that motion was denied. The matter was appealed, and eventually during that appeal process, a 3800B was filed, and that motion was also partially denied. It rendered a couple of the issues that are in the initial brief moot, which are outlined in the brief as no longer relevant to this court's determination. Without wasting any more time or abandoning any arguments, because I'm not abandoning arguments, I would like to focus my time, my 15 minutes of my rebuttal on the third argument I made in the initial brief, because I think that gives this court the greatest opportunity to correct the injustice in this case.
Mr. Candela, before you get to that, in the answer brief, the state raised the issue of the jurisdiction of the trial court to rule on the motion to withdraw the plea while the appeal was pending, and I don't believe a reply brief was filed. So can you address the jurisdiction issue? Sure,
Your Honor. And no, I did not file a reply brief. I believe that to raise the issues that needed to be raised in this case, a motion to withdraw plea had to be filed. I don't think that procedurally, the fact that the matter was on appeal removes the trial court's jurisdiction in that situation. The alternative would be is if you decide there is no jurisdiction, then this would have to fall under 3850 against the trial attorney for the previous trial attorney for not checking with his client before he filed an appeal.
But that motion hasn't been filed to date, correct?
No, nothing of that sort has been filed with the court, with either court. The motion to, I think this court has jurisdiction to hear this because of the substance of the issues. However, the trial court did address the motion. The trial court did not raise jurisdiction. obviously this court could say, well, that's a nullity if you find that there is no jurisdiction. However, I think the issues in this case were properly raised. If not in the motion to withdraw plea in the 3800B, which would still get to the third argument of the brief. So if the motion to withdraw plea is without jurisdiction, the 3800B denial does present these issues for this court to still rule on. I believe that should address the jurisdictional matter. What I'm talking about specifically in terms of the issues in this case is not count 3 of the informations, but counts 1 and 2, leaving the scene of the crash with death and the DUI manslaughter. And it is the appellant's position that these 2 charges should fall under yes, Your Honor.
Oh, go ahead.
Oh no, your square lit up. I'm sorry.
Nope.
They should fall under DUI manslaughter because of the way the legislature wrote the DUI manslaughter statute. Now, it's not quite a double jeopardy issue.
Mr. Candela, isn't I mean, I know you're talking about Blockberger and cases and related to that, but the simple reading of the charges, the DUI is a charge in the DUI with manslaughter, but the second offense that you're focusing on, the actual crime is the leaving the scene.
Yes, Your Honor.
Correct?
Correct.
So
I'm
why
focusing on
doesn't
count
that
3.
simple, just on the title of the charges, why doesn't that create a threshold that you can't overcome with regard to the Blockberger test?
Well, this isn't a Blockberger issue, Your Honor. This is not, and I think I was trying to be a little clearer in the brief. It's not a true double jeopardy issue. This is more akin to sentence manipulation and then a straight plain language assessment of the statute.
If it's sentencing manipulation, if that's a claim, is that still cognizable under 3800B?
Yes, because she would have pled to 2 charges which enhanced the maximum penalty beyond what it should have been, and it would have scored her to points greater than what she should have had. And so, like for instance, if you're looking at DUI manslaughter, the way it was charged, DUI manslaughter is a level 8, leaving the scene of the crash is a level 7. You add those points with the 120 for death, and you end up with 220 total points. After calculations, you get to 145.5 with a maximum penalty under the Criminal Punishment Code of 45 years. If you charge it the way the legislature added leaving the scene as an aggravator for DUI manslaughter and did the same thing for VHOM, so you can look at it that way. That's what that chart is on 35 of my motion. You end up with a different calculation. You end up with a total calculation of you end up with an enhanced charge of a level 9 DUI manslaughter leaving the scene as one offense, scores to 92 points. You add up all the calculations with the 120 for death, and you get 138 to a maximum of 30. So an illegal sentence under 3800B would absolutely cover this because it was charged wrong. Now, obviously, there was no objection at the trial level, but that's what the 38B allows.
So your argument is essentially a facial sentencing manipulation challenge?
Yes, ma'am.
/ double jeopardy?
Right. The problem is double. I didn't want to call it a double jeopardy. It's not really a double jeopardy, but there is no other category to put it into. And I'm not trying to hammer a square peg into a round hole just because it makes it easier to argue this thing. If you look at the way the statutes are written,
If we take it as sentencing manipulation, assuming that sentence manipulation is a basis for departure, then are you familiar with any cases applying sentence manipulation in a facial situation? In other words, isn't the cases when sentencing manipulation has been applied by courts, it's been based on the evidence in that specific case? rather than, a facial attack to a statutory scheme.
I am unaware of any case that fits the parameters that you stated, Your Honor. The problem that I come back to is reading a plain reading of 316-193. I think it's C3 is that when you read down the statute, you have the DUI manslaughter, and then it says, hey, by the way, if you leave the scene, that aggravates this from a second-degree felony to a first-degree felony. The legislature then also did the same thing in vehicular homicide as further proof that this is an aggravator for this offense. It's not a standalone. When DUI is charged or VHOM's charged, leaving the scene has to be an aggravator, not its own charge. Otherwise, the language that the legislature used makes no sense. Now, as I put in my brief, I think what happened is the legislature got really, really upset with what happened over in Tampa with the Jennifer Porter fiasco and said, well, wait a second, we're not going to let people get away with this. If they jake the system by running away and then, and manipulate the situation, then we want to be able to punish them. But that change to the statute doesn't supersede the way the legislature originally wrote the DUI and then the VHOM statute.
Mr. Candela, you've frozen again.
Used Lawrence. Lawrence is a second DCA case.
Mr. Candela, your video froze again right after you talked about, you said the word statute.
I think when you look at the stat, and I apologize, Your Honor, I haven't had a situation like this where my video does this. Looking at the statute, when you're looking at 316 or you're looking at VHOM, when you come down, there's an element of leaving the scene, which cites specifically to the rendering aid that uses the exact same rendering aid citation, which is 316-062. It cites squarely to it. Additionally, the Florida Supreme Court granted, the Florida Supreme Court doesn't approve the jury instructions, but the committees on these jury instructions have in the VHOM and in the DUI manslaughter statute an element already into the instruction for leaving the scene of the crash. There's all further anecdotal evidence. If you're not just looking at the statute, that leaving the scene of the crash can't be its own charge because of for several reasons. One is the one that I mentioned to Judge Sasso about you're manipulating the maximum penalty from 30 years, which would be a first degree felony, to 45 years by doing it the way it was done in this case. It should have been 30 years. But nonetheless, the state at the trial level argued the Lawrence case, and the Lawrence case doesn't hurt what I'm saying. It actually supports what I'm saying. In Lawrence, they said you could have these two charges together. But what I'm saying is you have to take it one step farther. They have to be combined as either the DUI leaving the scene, or if it was VHOM leaving the scene, because of the way the legislature wrote it. To come up with any other conclusion will render the second part of the VHOM and the second part of the leaving or the DUI manslaughter moot, because the state would always say, well, we can charge it this other way. We're going to charge it for 30 and then a second degree felony for 15 for a maximum penalty of 45. And that's not what the legislature intended. The legislature intended to be one charge. If you commit a DUI manslaughter and you drive off, run away, don't do what you're supposed to do under 062, then you are now also guilty of leaving the scene, which that is essentially what the leaving the scene charge is all about, is not rendering aid. So I don't know how they square without saying, hey, listen, this is an aggravation to this charge and it has to be one charge. The other case that I pointed out in the additional supplemental authority was the Johnson case. And this is where the Florida Supreme Court said, hey, listen, you're dealing with leaving the scene of the crash. It's a single victim crime. That's the unit, is to be by a single victim. So if it's 3 people in the car and you run away, it's 3 leaving the scenes. I'm assuming that it's not briefed in this case, but if there was 3 victims in the car and they were all killed and you ran away, it would be 3 DUI manslaughters leaving the scene. So I think that, the cases support the position that the legislature intended this to be one charge, so that you can't upward manipulate the amount of time that a defendant or an appellant in this case is looking at. I also think that and this is not a very strong argument, but it is an argument that I'd like to make, is just basically the lenity argument that the defendant should get or the appellant should get the most favorable construction of the statute when it's in doubt. And I believe that this is a situation, had it been raised to the trial court, I'm not sure what the trial court would have done with it, other than when it was raised in the 3800 and the trial court decided to just punt on it, I guess. I have 540, Your Honor. I would reserve from here.
Okay, you can do that. Mr. Palace, you may proceed.
Thank you, Your Honor. May it please the court, my name is Richard Palace. I represent the state of Florida. The state's position here is very simple, that none of these claims are preserved for appeal. The motion to withdraw a plea, it was not filed before the notice of appeal, which is when these situations where we will allow the trial court to continue its jurisdiction because a final order had not yet been issued in this case that would toll ruling. That's consistent under the rules of both Rule of Appellate Procedure 9600 as well as under the definitions in 9020. And also this double jeopardy, pseudo double jeopardy argument, that's not preserved by the Rule 38B2. That is talking about this as sentence manipulation. It was an objection that had to be made at the time of sentencing to the judge. It was not made here. If anything, double jeopardy could only be raised here because it would essentially weed out a conviction, not the sentences themselves, the conviction. That's not a sentencing error, it's a conviction error. And that is something that either had to be done by a timely Rule 3170 subdivision L motion, or more likely what has to be done here, a Rule 3850 motion. Besides preservation, there's no double jeopardy here. To both combat saying Blockburger is not at issue here, when it comes to whether prosecutor is allowed to charge and convict someone of multiple offenses, Blockburger is the issue here. The legislator is very clear in its rule of construction statute that the intent is to convict and sentence for each for each criminal offense, and not allow the principle of lenity is set forth in subsection 1 of that statute to determine the legislative intent. So in this case, it was proper of the prosecutor to charge both of these. And of course, because you have stopping and remaining under section 316.027, as well as willfulness in the language of that statute, yet those words are not involved in the DUI manslaughter statute. All DUI manslaughter talks about if this case was enhanced, which I believe under the new case law of State versus Misen and Maldonado, more than likely, while those original cases finding a violation were under single homicide rule, I believe that now under the Blockburger analysis, those wouldn't be at issue. If those wouldn't be at issue, this is not at issue. And again, appellant does not show any case law extending sentencing manipulation as a facial pseudo double jeopardy claim here. If this court has no other questions, I will rely on my brief and I'll ask that you either affirm or dismiss this appeal.
Thank you, Mr. Palace. And Mr. Candela, you have a little over 5.5 minutes.
Thank you, Your Honor. I think the state has missed what I'm saying. The statute before leaving the scene of the crash was elevated to a first-degree felony, you would have never seen this charged the way it is. And I'm not sure that that's a genuine argument. I mean, he's making the argument, but I'm not sure that that's before the legislature upped this to a first-degree felony. You would have never seen it charged this way. You would have seen it charged DUI, manslaughter, leaving the scene of a crash, all as one charge. The fact that the legislature now has decided that we're going to make the penalty greater for leaving the scene of a crash cannot and should not just be like, well, you can do it this way. That's not. I understand what you're saying about the facial argument, but a 3800B is allowed to raise sentencing errors. And if you're sentenced to greater points than you should have been sentenced to, I'm not saying that either one of these should be, I'm not saying that the two convictions should disappear. What I'm saying is it should be one conviction. The reason that there's not a case on this is no one's ever raised it. And that if that's the situation, then there's plenty of issues that come before courts as an issue of first impression. And I think that if that's the case, then this is an issue of first impression for this court and for this state. Because like I said, prior to leaving the scene of a crash becoming a first-degree felony, you would have never seen it.
Isn't sentencing manipulation? It's not an issue of first impression, though. It's I think what I find persuasive about it, that sentencing manipulation is based in due process concerns, and that in the context of sentencing manipulation cases has been a fact-intensive inquiry that isn't something that's based on the face of a sentence, right?
Yes,
So-
Your Honor.
So it would be extending, I guess it would be extending this doctrine into kind of uncharted territories. And so that, I mean, why would we want to do that?
Well, why? Because I think that the typically in sentencing and manipulation cases, you have a situation where law enforcement officers continue to make buys of larger amounts of cocaine or whatever the narcotic is until they get to trafficking amounts so that they can punish an individual greater than they could have the first time around. This is the same logic, but it's the state using a charging decision differently than it was intended. And that goes back to what I said about the prior to the new penalty for leaving the scene of the crash, the more logical application would have been DUI manslaughter, leaving the scene. Because the leaving the scene, I believe, was a third-degree felony. So it then aggravated the second-degree felony to a first-degree felony, and it made more sense to charge it that way. Now the state, because of
Mr. Candela, is what you're trying to tell us is that you're not permitted to have charges and convictions for both of these crimes as long as you do not use leaving the scene of the accident as an enhancement for the DUI manslaughter. If you charge them, you can charge them separately as long as you do not, and there can be convictions for both crimes as long as you do not use the leaving the scene as an enhancement. Is that what you're trying to say?
Yes, that is in a nutshell. But the problem is that leaving the scene of a crash has now been elevated to a first-degree felony. So it has a maximum penalty of 30.
So you can't charge based upon that. Your position is you can't charge two first-degree felonies from the same factual scenario, even if they involve different elements of proof?
No, that's not what I'm saying. What I'm saying is that the legislature wrote leaving the scene of a crash, which is the failure to render aid, already into the statute. By reading it the way the state's reading it, they're nullifying that aspect of the DUI manslaughter statute. They're saying, well, we don't have to do it that way. Even though the legislature already created a roadmap, we don't have to do it that way. We can now, because the legislature has given us a greater penalty, we can file a first degree and a second degree and maximize the appellant's total sentence to 45 years instead of being DUI manslaughter.
And Mr. Candela, you froze again. Mr. Candela, you froze again there, and it was right at when you were saying and DUI manslaughter.
The DUI, the DUI manslaughter has the component of leaving the scene, the rendering aid part. If you read it the way the state wants you to read it, you end up with you end up with a situation where you're writing out that part of the statute. It will never be charged. It ends up becoming a nullity because they'll always go to a first-degree felony for leaving the scene and a second-degree felony for DUI manslaughter, and it should be one. Thank you. I don't know. I shouldn't have any extra time, but I ask that you remand this for correction. Thank you.
All right. Thank you for both of your arguments, and we will stand adjourned.